You just inherited your family home. And it's not just a pile of bricks, it's a lifetime of memories. The kitchen table, where you battled through homework, the backyard where you learned to throw a ball, and the living room that soaked up decades of holiday cheer. What should feel like a blessing, a piece of your family's legacy, can spiral into a legal and financial nightmare before you know it. One wrong move with the title, a simple misunderstanding of the process, or one heated argument with your sibling could cost you thousands of dollars, months of your life, and worst of all, shatter your family. Are you ready for the 3 legal traps that catch almost every heir off guard? My name is Kathy, and I'm a probate real estate specialist. I've been in the trenches with countless families, navigating the exact situation. I've seen the wins and the heartbreaks. In this video, I'm going to show you exactly what these traps are and, more importantly, how to sidestep them so your parents' home can remain the gift it was meant to be. The first trap, probate paralysis. The most common trap is a huge misunderstanding about what happens the second a parent passes away. Most people think if the will says the house is yours, you just grab the keys and the deed is yours. That is dangerously wrong assumption. For most, the reality is a long, winding, and expensive road called probate. Probate is the official court process for validating a will, paying off the estate's debts, and legally transferring assets to the heirs. Now here's the catch. Even with a perfect will, you don't get to skip this. The house isn't legally yours until a judge says so, and that process can be a total beast. This is where you get stuck in what I call probate paralysis. The entire state is basically frozen. You can't sell the house, you can't refinance it, you can't even formally put it in your name. Meanwhile, the clock is ticking and the bills are landing on the doorstep. The mortgage, property, taxes, insurance, and utilities all still need to be paid. If the state runs out of cash to cover them, you could face late fees or even foreclosures. I've seen estates stuck in probate for a year, sometimes much longer. During that time, the housing market could tank, costing you tens of thousands in value. A pipe could burst, costing thousands of damage. And it's a legal gray area. Who's on the hook to pay for it? And to top it all off, probate is public. The state's finances, assets, and debts become public record for any nosy neighbor to look up. This paralysis creates a mountain of stress. You're trying to grieve, but you're also stuck in a court process that is slow, expensive, and just emotionally draining. So how do you break free? Through preparation and professional help. First, I have to clarify that probate isn't always mandatory. If your parents were savvy and placed the house in a living trust, or used a tool like a transfer on death deed, or held the probate in joint tenancy, you might get to bypass the probate entirely. But if the house is only in the name and is being passed down through a standard will, you're heading to probate. Seriously, this is not a DIY weekend project. An attorney guides you through the maze of court filings, deadlines, and legal notices, making sure it all gets done right and as fast as possible. While you can't go back in time and set up a trust for your parents, you can control how you handle the here and now. Get organized, be patient, and get a professional on your team from day one. Understanding that probate is a marathon and not a sprint will save your sanity. The second trap, the sibling standoff. All right, trap number 2 is the one that can burn family bridges to the ground, the sibling standoff. This is what happens when the will says the house gets split equally among the kids. Sounds fair, right? In reality, it's often a complete recipe for disaster. All of a sudden, you and your siblings are co-owners of a very expensive, very emotional asset. And I guarantee you won't all want the same thing. I've seen this movie 100 times. One sibling needs cash and wants to sell yesterday. Another is horrified at the idea of selling their childhood home. And wants to keep it for sentimental reasons. A third, the practical one, suggests renting it out for income. And then there's the fourth sibling who was living there with your parents, who now feels they have a right to stay, maybe even rent-free. So who wins? Without a clear plan, nobody. Resentment builds as you argue over who's paying for upkeep, taxes, and insurance. What happens if the roof starts leaking? Does everyone chip in? What if one sibling can't afford their share? This gridlock can go on for years, poisoning relationships. If you truly can't agree, any sibling can take the nuclear option. They can go to court and file a partition action, which is a lawsuit that asks a judge to force the sale of the house. Not only is the sale guaranteed, but the legal fees from the court battle will chew up a huge chunk of everyone's inheritance. It's the option of last resort, and it leaves permanent scars. The only way out of this is to treat it like a business deal from the get-go. Your feelings are real and valid, but they can't be what drives the financial decisions. As soon as you can, all the heirs need to sit down for a frank conversation, ideally with your attorney or a neutral mediator, to keep things from going off the rails. You need to discuss the three main options. 1. Sell and split. This is usually the cleanest path. You sell the house, pay off any costs, and split the cash according to the will. Everyone gets their share and can move on. 2. The sibling buyout. If one sibling desperately wants the house, they can buy out the others. First, you get a professional appraisal to set a fair price. Then, that sibling has to get a loan or use other assets to pay the others for their shares. This has to be locked down in a formal legal agreement. 3. Co-own as an investment. If you all agree to become landlords, you need to form a real business partnership. That means creating a legal operating agreement that spells out everything: who manages the property, how you split profits and costs, and an exit strategy for when someone eventually wants out. No matter which probate you take, you have to finish the probate process first to get a clean title with all the heirs' names on it. Without that, you can't legally do anything. By the way, if you're getting some value out of this breakdown and want to help protect other families from these headaches, do me a quick favor and hit the like button. It really helps. The channel gets this info out to more people. The third trap: the hidden costs and tax bombshells. The third trap is the sneakiest because it's a surprise attack on your wallet. You think you've inherited this valuable asset, but what you're actually inherited is a bundle of hidden debts and expenses that can bleed you dry if you're not ready. Let's be clear, a free house is never free. The moment it's yours, you're on the hook for a constant flow of bills, property taxes, homeowners insurance, utilities, general upkeep, and maybe an HOA. If this is an older home, you could be looking at a surprise $20,000 bill for a new roof or a dying HVAC system. And here's another big gotcha that many people miss: property tax reassessment. In many states, the transfer of ownership to an heir triggers a reassessment of the property's value, which caused your annual property tax bill to skyrocket. But the real bombshell is usually taxes. And I'm not just talking about the federal estate tax, which only hits massive estates. Several states like Pennsylvania, New Jersey, and Kentucky have their own inheritance tax that you, the heir, have to pay. The biggest tax question, though, is usually about capital gains when you sell. Most people have this paralyzing fear that they'll owe taxes on the massive profit from what their parents paid 40 years ago versus what the house is worth today. This panic can lead to some really bad decisions. The solution is to arm yourself with knowledge about a crucial tax rule called the step-up in basis. Here's how it works. For tax purposes, the cost of your inherited home isn't what your parents paid. Instead, the cost basis gets stepped up to the fair market value on the date your parent passed away. For example, your parents bought their house for $50,000 in 1985. On the day they passed, it was appraised at $500,000. That $500,000 becomes your new cost basis. If you turn around and sell it for $510,000, you only owe capital gains tax on the $10,000 profit you made, not the $460,000 of appreciation that happened over your parents' lifetime. It's a huge tax break. Now, I have to give you a major heads up here. As of mid-2025, this step-up in basis rule is facing some serious challenges from lawmakers. There are active proposals that could limit or even get rid of it, especially for larger estates. So while it's a law of the land for now, you absolutely have to check the current rules when the time comes. Your action plan is this. First, get a home inspection and create a budget for all the property's expenses. Second, talk to a CPA or financial advisor before you sell. They can confirm current tax laws, help you calculate any state inheritance tax, and figure out your potential capital gain hit. Knowing the actual numbers turns financial panic into a smart, manageable discussion. Look, inheriting your parents' house is emotional, but it's also a major business transaction. The traps of probate, sibling fights, and hidden costs are very real, but they are absolutely avoidable. And before we wrap up, I want to squash a nasty rumor that keeps popping up online. No, there is no federal law taking effect in 2026 that bans children from inheriting their parents' home. It's misinformation, plain and simple. Let's recap the real traps. 1. Probate paralysis, the court system freezing the house. The fix, get a probate lawyer on day 1 and know the process. 2. The sibling standoff, when sharing the house tears the family apart. The fix, communicate, treat it like a business, and sign a formal agreement. 3. The hidden cost nightmare, the wave of surprise bills and taxes. The fix, budget for expenses and get professional tax advice to leverage the step up in basis while you still can. The theme here is simple: to be proactive and get help. This isn't something you should try to figure out alone while you're grieving. Honestly, the most important step you can take right now is to build your team. A sharp probate attorney, a real estate agent who knows inherited properties, and a CPA you can trust. They will be your shield, guiding you to the best possible outcome. If you have any questions or if you're standing at the beginning of this process and feel lost, please reach out. We're here to help you get through this with the clarity and peace of mind your family deserves. Thanks for watching.